Hello, everybody. This is Jennifer Schaus coming to you live from Washington, D.C. Thanks for joining us today in our Webinar Wednesday series. Every Wednesday throughout the entire year in 2018, we are conducting a webinar, and the speakers are industry experts, including attorneys, accountants, and other industry professionals. Our full schedule is on our website under the webinar section, and all of the recordings are listed below that under the archive webinar section. You can also find the archive webinars on our YouTube channel. Also, in the interest of time today, we are not taking questions. So if you have any questions for our speaker, you can send them to her directly. And Maria's contact information will be listed on the last slide. A quick blurb about us. We are based in downtown DC and provide professional services for product and service companies that are selling to the federal government. Our services include anything from market analysis reports to contract administration, proposal writing, GSA schedules, 8A certification, and more. Throughout the year, we do host various seminars and conferences as well as networking events, and those are all listed on our website as well. A little bit about our speaker, Maria Panichelli, is listed here on this slide. And today she is covering Partnering to Win on Federal Contracts, a primer on teaming and joint venturing. So we're lucky, very lucky to have Maria with us today. And thanks again, everybody, for tuning in. So Maria, I will turn the floor over to you, and thanks again for joining us.
All right, great. Thank you so much, Jennifer. And thank you, everyone out there, for joining us today. We are going to be talking today about Partnering to Win on Federal Contracts, the very hot topic, or topics, I should say, of teaming and joint venturing. First, I just want to give a real brief, description of me and my firm. I work at Cohen Seglius Pallas Greenhall and Furman. I'm a partner in the Federal Contracting Group, so that means I focus exclusively on federal contracts, everything from the pre-proposal stage through performance and performance counseling, up through if there's any REAs or claims involving protest issues as well, and then of course all of the small business stuff. And what we're going to be talking about today is kind of a large part of my practice, the teaming and joint venturing that comes along with the small business stuff. Next slide. So we're going to start off today. As I said, teaming and joint venturing are some of the hottest topics in government contracting. They have been for a couple years now, many years now. But what's curious to me and what's always been surprising to me is that as much as they're talked about, they're often misunderstood, and there's some big misconceptions about each of the concepts. And furthermore, there's a lot of confusion between the two concepts, what the differences are. And we're going to try to clear those up today. And I find that usually the best way to do that is to start with making sure that everyone understands the building blocks. So for some of you, this might be a brief refresher, but for those of you who don't know, the key to understanding all of this is first to understand what a small business is. And believe it or not, there are still a lot of companies out there that do business with the federal government that don't understand that quote unquote small has a very special meaning when it comes to federal government contracting. Before I started practicing law in this area, I think I had the common conception that a lot of people have that a quote unquote small business is a family-owned hardware store on Main Street, USA, or the local ice cream shop around the corner that's owned by a couple or a father and a son, etc. With the federal government contracting, small business is a very specific type of business, and it's not necessarily what we normally think of as a small business. What it means is that for every set-aside contract, and we're going to talk about what those are in a second, they have something associated with them called a NAICS code. Basically, every federal government contract is assigned a NAICS code that has something to do with its industry. In other words, if you're doing residential construction, you're going to have one NAICS code. If you're doing civil engineering, you're going to have another. If you're doing cybersecurity, you're going to have another. And then there are what are called size standards associated with each of those NAICS codes that tell you what is the largest a business can be to still be considered small for purposes of performing contracts with that NAICS code. That size threshold can be either in terms of employees or in terms of revenue. And as long as you stay under that, then you are quote unquote a small business for purposes of that NAICS code. So for example, if you are doing construction work and you have a contract with one of the construction code NAICS codes, The size standard associated with most of those with general construction is going to be 36.5 million. So it's a receipts-based, not employee-based size standard. And what that means is as long as you are under 36.5 million average receipts over the last 3 years, then you are considered small for purposes of contracts with that NAICS code. You are a small business. What the government does is it sets aside certain contracts for small businesses, which means that only people or only companies that qualify as quote unquote small can even compete for those contracts. There are also other small business programs where one of the prerequisites is that you're a small business, but then you have to meet additional criteria and you can be part of these other programs. The other small business programs that are out there, the primary ones are the 8A for small disadvantaged businesses, hub zones for businesses that are located in what are called historically underutilized business zones. Those often include urban areas, really very rural areas, Indian reservations, etc. There's also the SBA and VA, both have programs for veteran-owned business, service-disabled veteran-owned business. And then finally, there's also the woman-owned and economically disadvantaged woman-owned programs that are run by the SBA. So if you are not aware of those programs, you should definitely talk to an expert about whether or not you are eligible, because that's going to allow you to compete for those set-aside contracts that are basically put out by the government and only can be bid upon by people within the certain programs. So those are two of the most fundamental concepts here, small business and set-aside contracts. The other thing that you have to keep in mind to understand what we're going to talk about today is affiliation. Now, we touched upon what small is. Affiliation can affect your size because if two businesses are considered affiliated, their size is going to be aggregated, and then their aggregate size is going to be compared to that size standard we talked about. So if you're a small business and you're found to be affiliated with a large business, then poof, all of a sudden you're not small anymore. And you're not going to be eligible for those set-aside contracts. And that's going to become important later as we go forward talking about these things. And finally, I find that it's really important to approach this whole area of teaming and joint venturing by thinking about why people team and what the goals and the purposes really are that are associated with teaming and joint venturing. So we talked about set-aside contracts. There has been an uptick or an increase in the amount of contracts that the government has quote unquote set aside for small businesses or for businesses in the various small business programs. So that means that a lot of large businesses out there are wondering, okay, there's a decreasing amount of just open, unrestricted contracts for me to compete for, and there's an increasing amount of these set-aside contracts. How can I get access, or how can I try to take advantage of those opportunities when I'm not a small business? Meanwhile, small businesses might be wondering, how can I compete with regard to the various non-price factors? I might be able to, if you're going after a procurement where past performance is a requirement, or you have got certain levels of capability that you need to demonstrate. A lot of times small businesses aren't necessarily able to compete with larger businesses on that kind of level with those kind of characteristics. So the answer oftentimes is to form a team or a joint venture so that you can go after these set-aside contracts as some sort of partnership between the large and the small business. That allows the large business to leverage the small business's eligibility for set-aside contracts, and it allows the small business to leverage the large business's capability, size, past performance experience, etc. Next slide. So once you kind of decide that there's a need and that you think you want to team up in some way, you have to think about what type of partnership or what type of relationship you want to set up. And there are differences between teaming and joint ventures and also MentorProtege, which sometimes gets lumped in here in the teaming and joint ventures category. Teaming is just a special type of prime subcontractor relationship where usually, and we're going to talk about this in a little bit, but usually you've got the prime contractor who is a small business because they have the eligibility to go after those set-aside contracts, and then the large business is the subcontractor. Joint venturing is a little bit different. That's two companies coming together, and instead of having one company be a prime and one company be a sub, they form a joint venture, and that joint venture is the prime that then will go after contracts. And depending on what your needs are, as we're going to talk about as we go forward today, you're going to want to try to decide which setup is better for you. Now, like I said, MentorProtege sometimes gets lumped in here because there are MentorProtege programs which allow you to skirt certain affiliation rules with joint venturing, which we're going to talk about. But for our purposes, what you should always keep in mind is that the MentorProtege programs are government programs that allow companies to form specific types of relationship for the purpose of the development of the protege company, and that's always going to be the SBA's primary focus. Next slide. All right, so when you're trying to decide how you want to set up your partnership, we're going to talk about some of the major differences. One of them is who is the prime contractor. We just talked about this a little bit, but just to reiterate, teaming, you're going to have the small business serve as the prime contractor because they're the person who's eligible for that set-aside contract. They are either small or they are small and a participant of the specific program, 8A, Hub Zone, Service Disabled, Veteran Owned, etc. So they're going to be the prime contractor, and they're going to team up with a teaming partner, a subcontractor that's going to be a pretty dominant subcontractor or do a large chunk of the work, and that sub is going to be a large business. Joint venture, again, you don't have one prime and one sub. The two companies are going to come together, form a joint venture, and then the joint venture itself is going to be a prime contractor on the contract. Now, the joint venture can subcontract to one or all of its joint venture partners if it wishes, but for purposes of trying to figure out how to set up your partnership, these are things you're going to want to think about, because depending on if you're large or if you're small and how much control you want and how much control you're willing to give to the other party, you're always going to want to think about who you want to be the prime, who you want to be the sub, and who you really want to be running the project. Next slide. One of the other major differences is affiliation. Now, we talked about that up front. Remember that affiliation is or can be problematic because it can mean that a large and a small business, their sizes are aggregated for purposes of determining whether or not if a business is small. So one of the major things that often deters people from forming a joint venture and leads them kind of more into the teaming realm is this affiliation issue. Because the general rule is that members of a joint venture are presumed to be affiliated with each other for purposes of any contract for which the joint venture competes. So what that means in layperson language, in non-legalese, is that if you, a small business, want to form a joint venture, and you've got this large business that's really interested in partnering with you, they want to leverage your eligibility, you want to leverage all of their capabilities, but they're large. And if you want to form a joint venture, your size for purposes of that joint venture is going to be aggregated. Your size plus the large business's size equals the joint venture size. And if the large business is a large business, the JV is necessarily going to be a large business. So what most people don't want is to have a joint venture that's large or quote unquote other than small, because then that joint venture isn't going to be able to compete for set aside contracts, which, remember what we talked about at the beginning, is kind of the whole purpose of this teaming and joint venture thing. So you need to think about whether or not there are exceptions to this rule. General rule, members of a joint venture are going to be presumed to be affiliated with each other. Their sizes are going to be added together. The joint venture is going to be considered whatever size that aggregate is. But there are two exceptions. If both of the joint venture partners are small, then the joint venture is small. More commonly, and remember the example I talked about involved a large company and a small company, that's where this other exception can come in, and that's why MentorProtege gets lumped in with teaming and joint venturing. If a large business and a small business form a mentor-protege relationship and get that mentor-protege relationship approved by the SBA prior to entering into a joint venture, then that joint venture, as long as it complies with certain rules and regulations, is going to be considered small. Next slide. So those are usually the two major things you need to look at when you're thinking about, okay, do I want a team or do I want a joint venture? Think about, who you want to be the prime, how you want to structure it, how much control you need to have, how much control you're willing to give up, how you want to work out kind of the chain of command between prime and sub, and what does that mean in terms of if you want to have a joint venture or a teaming agreement. Moreover, you want to think about what is going to happen to you with regard to affiliation. Are you both small businesses, or is it one small business and one large? Do you have time to go through the mentor-protege process? Are you willing to go through all the steps that we're going to talk about in a little bit that are required to go through the mentor-protege process? If not, then maybe joint venturing is not for you and you should be looking at teaming instead. All right, so now we're going to talk a little bit and I guess I should say first, if you are kind of on the fence and if you found a partner but you're not sure yet which way you want to go, teaming or joint venturing, that's really when you should talk to a consultant like Jennifer or to a legal expert like myself or a lawyer who practices in this area. They really can help guide you with regard to what is a better fit for you and whatever partner you're thinking of teaming or joint venturing with. Then once you figure that out, then there are a whole host of additional considerations, which is what we're going to talk about now. So if you decide to go with a teaming agreement, there are some essential considerations that you want to think of. The first is something that we call exclusivity. And what we say is there's generally 3 E's that need to be considered in teaming. Exclusivity is the first one. And what that means is, are you only allowed to team with each other, or can you enter into multiple potential teaming agreements? Now, remember, one of the purposes that we talked about up front was the ability for small businesses to leverage a large business partner's capabilities. So if you're a small business and you team up with a large business so that you can compete and so that you can say, hey, my teaming partner's got all this great experience. So together we knock it out of the park with regard to all of these past performance and non-price factors that are being evaluated as part of the source selection process. Well, if your large business teaming partner has teamed with 3 of your competitors also, so all 3 of you are able to submit a proposal that says, look at all my experience, but look at all my teaming partner's experience. Well, you don't really have a leg up anymore because you, as well as all of your competitors, have just leveraged that large partner's experience. So as a small business, a lot of times what you want to think about is, can I get this large business to agree to be exclusive? Can I say, hey, you only want to team with me. I don't want you entering into teaming agreements with 3 other people. Large businesses often will want to make sure that they are not exclusive. They want to say, I want the subcontract, whether I don't really care who gets the prime contract. I want a subcontract. I want the money. That's my whole purpose. So I want to be able to team with multiple people. And again, this is something that you're going to want to work out between you and your potential teaming partner, whether you're willing to be exclusive, how long the teaming agreement lasts. If you've got a task order situation, is it exclusive just for this task order or any task order under this umbrella, etc. Enforceability is another concept that you're going to want to talk about. Enforceability depends a lot on state law of the state that you're trying to enter into a teaming agreement with. Oftentimes it depends on how specific your teaming agreement is. And again, that's something that my colleagues and I help people with all the time. We know what is and what isn't enforceable, but the general thing to keep in mind is the more specific and concrete you are in your teaming agreement, the more likely it is to be enforceable. If you kind of just have vague ephemeral promises that, yeah, maybe if we win this proposal, we're going to subcontract, that's likely to be deemed unenforceable. Whereas if you have a situation where you say attached is a draft subcontract, and within 3 days of the prime contractor small business being awarded the proposal at issue, they will issue the subcontract or execute the subcontract in the attached form. Those are the types of things that start locking people in and showing that there's more concrete intent to bind the parties, and that's when a teaming agreement is going to be enforceable. The third E that you need to think about when you're talking about teaming is expectations. And that's really just everything that you normally want to think about in terms of any subcontract. You want to make sure you're all on the same page in terms of who's performing what work, in terms of the other 2 terms that we just talked about, in terms of governing law, in terms of term and termination, in terms of who's doing what and who's contacting the owner, in terms of who's responsible for lower tier subcontractors, etc. It's just catch-all to make sure that you're really thinking about all of the various issues that you need to work out. So what we say is best practices is to always submit as part of your teaming agreement a draft subcontract and to specify when and how that subcontract goes into effect. And you should, in that subcontract, cover all of the stuff that we just talked about, the exclusivity and the expectations. And if you do that, that's the best way to make sure that your teaming agreement is enforceable. And if you have any questions, it really pays to consult with a legal expert who is familiar with these things. Next slide. All right, so what can go wrong in terms of teaming agreements? The most common pitfalls are affiliation, control, and running afoul of the work percentage requirements. Now, we already talked about affiliation, but mostly we talked about it in the context of joint ventures. But that's not the only time affiliation can come up. You can have affiliation in a variety of circumstances, and pretty much any time you're not observing corporate formalities between two companies. If you share office space or share employees or share materials, or if you're subcontracting so frequently that you're reliant upon each other, or if you have familial relationships across companies. There's a whole host of things that can get you in trouble in terms of affiliation. But the one that comes up most often in teaming agreements is what's called ostensible subcontractor. And that is when you have the prime contractor functioning as a prime only in name. And what that means is when you've got a team, you've got that small business prime, and you've got that large business sub, but maybe the large business sub is taking over and controlling the job a little bit too much. What can happen in that case is that the companies can be deemed affiliated, and obviously then their sizes would be aggregated and the small business would lose their small business size status, not just for purposes of the contract that they're working on, but theoretically or possibly for others as well. So that's something you have to want to work out or watch out for. That can also affect the control component. All of those small business programs that I talked about before have a component of a requisite individual, whether it's a woman or a service-disabled vet or a socioeconomic disadvantaged person, being in quote-unquote unconditional control of the company. When you have a sub that's controlling your job, sometimes that can affect the SBA's idea of whether or not you are controlling your company, and that can run you afoul of those eligibility requirements and nullify your small business program eligibility. And finally, as many of you may know, there are certain regulations that govern what percentage of work a prime contractor has to perform themselves on a set-aside contract. So if you have a set-aside contract situation and your subcontractor is performing too much of the work, then you run afoul of this and you can get in trouble. That can affect your eligibility, even though technically it's supposed to affect something called responsibility. SBA often takes that into account. So these are three things that you need to watch out for when you're teaming. You're going to want to set up your teaming agreement in such a way to avoid these, and it's something that you're going to want to make sure you have somebody, an expert in the field or a legal consultant look at to make sure that you're not doing anything that's going to jeopardize the small business's eligibility, because that hurts the small business. Obviously, they can't go after set-aside contracts anymore, and it hurts the large business too, because the whole point of teaming was to get access to those small contracts, set-aside contracts, excuse me. Next slide. All right, so that was kind of a primer on what you need to think about when you decide to team, but what about if you go the other way, if you go for a joint venture? Some real quick things to keep in mind about a joint venture: has to be in writing. Joint venture has to be doing business under its own name. You have to be identified in SAM, so in other words, it's not enough that each of the joint ventures registers in SAM, or joint venture partners registers in SAM. Once you form the joint venture itself should register in SAM and make it clear that it is a joint venture in its SAM registry. It can be in the form of a formal or informal partnership, or exist as a separate LLC or other separate legal entity. Next slide. The other thing that you have to keep in mind is who the JV partners are. Again, we talked about if it's two small businesses, you're pretty much golden. You fall into that exception of, okay, great, small business plus a small business. If they're both small, the joint venture is small. But if you have a large and small business that want to joint venture and go after set-aside contracts, then remember we talked about that general rule. As a general rule, the two partner sizes are going to be aggregated, and the JV is going to be considered large if the aggregate size is large. So if you want to get around that, if you're a large business and a small business that want a JV, you have to do a mentor-protege agreement and get that approved, and that's a prerequisite. Next slide. So the mentor-protege program, there used to be just one, used to be only eligible for 8As, or I'm sorry, only 8As were eligible. Now there are two. As of, I think about a year and a half ago at this point, there is the new all-small mentor-protege program, which means that other participants in small business programs, 8A, HubZone, service-disabled, veteran-owned, and women-owned, as well as just regular small businesses, can enter into the mentor-protege program. Remember, again, the SBA views the purpose of these programs as the business development of the protege firm. So even though a lot of companies want to get into the mentor-protege world just to get around that joint venture problem and be able to joint venture, the SBA is not going to approve the joint venture if it looks like that's the only reason that not going to approve the mentor-protege relationship if it looks like that's the only reason these businesses have come together. So they're going to look at, is the mentor really going to be giving the protege the help that they need to meet their business goals, et cetera. And as part and parcel of that, there are eligibility requirements in order to be a protege. There are eligibility requirements in terms of who can be a mentor. And then there are certain very stringent written agreement requirements that the partners need to meet and agree on and come up with a written agreement that meets a laundry list of criteria. Frankly, we could do an hour-long webinar just on the mentor-protege program, where we're trying to hit the highlights here. Then after you get the written agreement together, there's an application process, a review process, and the SBA will either approve or reject the mentor-protege agreement. Again, I will say that I've seen several rejected when it looks like the only reason that two companies are teaming up is to form a joint venture. You have to make very clear how the protege is going to be helped and how the mentor is going to use their capabilities to help the protege grow. There are also ongoing evaluation and reporting requirements. The protege basically has to report on a contract by contract and yearly basis what help they're getting, how they're developing, and how the mentor-protege agreement is working out for them. But if you're willing to go through all of these steps, and if you're willing to, really do what you need to do, and if the mentor is willing to give the help to help the protege grow, and if the protege is willing to take on these onerous approval and reporting requirements, there are some great benefits. Not the least of which is what we just talked about, that the two can joint venture for any contract that's small, and that they can joint venture for any contract for which the protege concern is eligible. So if the protege is an 8A or a woman-owned, the JV could go after 8A or woman-owned contracts as well as just small set-aside contracts. In addition, the mentor can buy up to 40% of the protege concern. So they can have a minority ownership interest in the protege, and the protege can thereby raise capital. And you can do that without running into any other affiliation or control concerns that you would normally have. So those are some really good benefits of the mentor-protege programs, and that's why so many companies are joining together and forming mentor-protege relationships so that they can then go on and form these joint ventures. And again, this is something you need to do in order to form the joint venture if you want the joint venture to be eligible for small or other sorts of set-aside contracts. Next slide. Now, in addition to going through all the mentor-protege stuff that we just talked about, if you want your joint venture to be small, you have to meet other certain requirements. And again, this is another thing where it really pays to know the general areas that you need to comply with, but talk to an expert, a consultant, or a lawyer in order to kind of drill down. You need to have a written agreement, and that written agreement has to have very specific provisions. The regulation 13 CFR 125.8 lays out 11 or 12, I think it is, separate things that you need to include. You also have certain performance of work requirements. Specifically, the small business or the protege concern needs to be performing 40% of the work that the joint venture is doing. So that's something to keep in mind. You don't want to go through this whole mentor-protege process and then find out that your protege can't do that much work. So definitely keep that in mind when you're thinking about whether you want to joint venture or whether you want a team. In addition to meeting those requirements, you also have to file regular performance of work reports that certify that you're complying with that 40% requirement. You have other filing requirements in terms of certificates of compliance, and you have to make sure that you're always open for an inspection of records. And if you fail to do any of these things, not only could you possibly lose the small business eligibility, not only could they then, face fines or, certain problems with the SBA in terms of getting rejected for future set-aside contracts, but under the new regulations that came out in 2016, if you fail to do any of these things, or if you falsely certify your compliance or are falsely certifying your performance of work reports, these are all things that are a basis for suspension or debarment. So it's really important to understand the requirements you need to meet in order for your joint venture to function properly. And 13 CFR 125.8 is a really good place to start. That's going to tell you everything you need to do in order for your joint venture to be quote unquote small. And that is in addition to getting approved as a mentor-protege relationship prior. Next slide. And then in addition, remember I talked about the fact that once you go through that mentor-protege process, the joint venture is going to be eligible for any type of set-aside for which the protege is eligible. So if the protege is a woman-owned small business and you get through the mentor-protege approval process and you form the joint venture, you're going to want to make sure that not only does your joint venture comply with the regulations we just talked about on the previous slide, but for each one of the program, there are additional requirements, specific program requirements. And I've set forth the specific CFR sections here on this slide. But again, just as an overview, what's really important is to make sure that you understand what the common pitfalls are in teaming, what we talked about earlier, affiliation, control, and percentage of work requirements, and to understand what the kind of onerous provisions can be with joint ventures, and that's going to help you decide what's best for you. What we usually see is that companies that kind of want a down and dirty, quick partnership, they've got a proposal coming up quickly that they want to get a teaming agreement together and be able to compete in a short turnaround time. They're usually going to go the teaming route, and it's going to be all about putting together the most airtight and forcible teaming agreement, making sure all the parties are on the same side or on the same page. The people who want more of a long-term formalized relationship, those are the people that are usually going to want to take the time to go through the mentor-protege approval process, take the time to consult with a lawyer or another government contracting expert, make sure that they've got all of these provisions and all of the joint venture provisions taken together, and they're going to go the joint venture route. But you shouldn't jump into either one without understanding that there are options, understanding what the pros and cons are for teaming and for joint venturing. And hopefully today gave you a little bit of a primer and an overview of what some of the issues are, so that you can figure out in any specific instance or any specific potential partnership you might have, what relationship would be better for you. Next slide. We kind of covered the highlights today, but obviously this is a dense area of the law, and it can be a complicated and interesting area. So if you have any more questions, feel free to contact me. My phone number and email are on the screen. Always happy to take your questions. And with that, I will turn it back over to Jennifer.
Maria, thanks for excellent presentation and sharing your great knowledge on this hot topic. And thanks everybody for joining us today. Again, Maria's contact information is there on the screen. You can contact her directly. Next week, which is Wednesday, April 18th, we are covering proposals to DARPA, IARPA, and BARDA. The week after, which is Wednesday, April 25th, we are covering cost proposals. The full schedule is on our website under the webinar section, and today's webinar has been recorded. It'll be available later today on our website. Thanks again, Maria, and thanks again to all the attendees who took time out today.
Thank you very much.